In ThinkHouse, we have regular litigation updates, usually focusing on the law. Have you breached a contract? What's the consequences for damages if you breach that contract? But of course, that is not the whole picture in litigation. The allocation of cost and the strategy behind that is also a key part in deciding whether you fight or not. In this session, Clark Sargent, partner in our dispute resolution group, is going to lead us through the changes following the Jackson reforms, the impact it has on costs and litigation, the strategy for litigation, and he will also look at settlements and mediation. Clark, can you explain this new idea in litigation of cost budgeting in the Jackson reforms?
In 2010, Lord Justice Jackson produced his report on costs in civil litigation, and those have led to what are obviously called the Jackson reforms. And it is, like it says on the tin, all about costs in civil litigation, which the courts and the government are keen that we contain, control, keep in check. One of the things that Jackson has brought in to help with that is this idea of very early cost budgeting. And how that works is at the start of a case, and by the start of a case we mean that you will have had a claim letter, there'll have been a bit of pre-action exchange, a claim form will have gone in, the defence is filed. At that point you are meant to be able to see roughly what the case is about, what's an issue, what's agreed. You might have some idea about what the documents will be and how the witnesses will play out and whether you need experts or not, because you've got the claim form and the defence. And at that point, just before you go to court for the case management conference, you put in your cost budget, telling the court, but also telling the other side, and indeed telling your own client, what you think the cost will be to run it, not just to where you've got to or a little bit further on, but to trial. And you set your cost budget at that point. You tell the court what the budget will be, and the court will then consider that and decide whether it's a proportionate budget in the context of the claim that's before it. And if it likes the budget, it will approve it. And if you have an approved budget here early on, then that will set, in all likelihood and give or take a little bit, what you will get back as your costs if you win at the end of the claim. That means that all of the parties and the court should be able to measure the cost risks of this litigation very early on. And the winner can see what it might get back as its recoverable costs against what its actual costs might be, and the loser can assess what the risk would be if you lost the claim, your costs and other side's costs. So it's designed to allow the parties to understand not just the legal risk but also the cost risk early on.
If you don't submit your cost budget on time, what are the consequences?
If you don't get your cost budget in on time, then the court will award you an approved budget of court fees only. That means no lawyers' costs, no counsel costs, no expert costs. Your budget for the entire litigation is set at only the court fees that you will incur as you go through the case. If you're a claimant, that might mean a couple of £1,000. If you're a defendant, that might mean a couple of £100. That is going to be a very significant shortfall on what you actually spend. That sounds like a harsh sanction, but it is undoubtedly the ones that the courts will consistently apply, because this was the lead case on the new procedural regime. Andrew Mitchell, the Plebgate affair, and articles on him in the Sun newspaper, and he sued them in defamation, and his lawyers were late getting the cost budget in. And even if the court had had any sympathy with his solicitors, which they did not, but had they, he had no good reason to be late with his budget, and he has been awarded court fees only as his approved budget, and he will now have to take on the Sun newspaper with a budget at the end, if he wins, of only a couple of £1,000. It is worth just also thinking about making sure that your budgets go in on time. And we've spoken about the courts approving budgets or not approving budgets. Obviously, if the court likes if you get your budget in on time and the court likes your budget, you will come out with an approved budget that is something that you and your lawyers have put together and are to some extent comfortable with as your budget. If the court doesn't like your budget, but you're in time, the court cannot approve a budget. But if it doesn't approve a budget, it doesn't mean that you have no budget. It simply means that you have a budget that hasn't been approved by the court. And therefore, if you win, when you get to the cost assessment at the end, you'll still need your budget assessed in the context of the budget that you put in at the start, in the context that the judge didn't like that at the time, but you will still just go through a standard assessment. So you are still in the game. You are going to get some costs. If you are late with your budget, you will get nothing bar court fee. So it's a big differentiator. So if your budget's about right with 8 days to go to the CMC, put it in, because it's better to be about right than to take a couple of extra days making it perfect and being late.
Are you able to apply for relief from sanctions? And what are the chances of getting it?
That's a question that goes outside just cost budgeting, but levering off the Mitchell case, the answer is, of course, you can always apply for relief from sanction. And indeed, if you miss a deadline, you really must apply as soon as you can for relief from sanction. Whether you will get it is a wholly different question, and the answer is it's very hard to get relief from sanction. The courts over the last 4 months have been laying the marker down that relief from sanction is hard to get. You will only get it, and this all comes from the Mitchell case, if your breach is trivial. And trivial is narrowly defined as a narrow miss on a timetable, a narrow miss, and that's sort of going to be measured now in minutes and hours, not in days and weeks. We are talking about a very small overrun. Or if your breach is deemed to be form, not substance. And there have been a couple of cases on that as well. If you aren't just guilty of a trivial breach, most breaches will not be trivial because of how narrow trivial has been defined, then you need a good reason for your breach. And good reason, again, has been very narrowly defined. In the cases that we have seen so far, it isn't that the parties have just underestimated how long something might take, although the court does mention that as a reason. If genuinely earlier on in the case you had thought you could do disclosure in X weeks, but actually it will take Y weeks, that's something you can go to court on. But in most of the scenarios that we've seen so far, it is a party or a solicitor acting for that party has missed a deadline. And there, the court says, good reason would include something like a debilitating illness. And that's quite a high test if you think what debilitating means. A debilitating illness or an accident. So, we're talking about unpleasant things to go to court to say, this has caused me to be late. So it is a narrow test, and in most of the cases that we have seen, relief has been applied for and it has not been given. The courts have been setting down a clear marker that relief is hard to get.
Is this just about cost budget, or is it also about other events in the court timetable?
This is everything. So we have seen, but you have to remember, of course, if you don't get relief, so you miss a deadline, a sanction applies, which is because you missed the deadline, the thing that you're trying to serve, you now can't use, you can't rely on it. Well, that can be fairly terminal to a case. And we have seen cases on claim forms, late, claim is gone, out of time. So the rule just says there is no claim, the claim's gone. Particulars of claim, again, effectively your claim's dead without a particulars of claim. Disclosure, and if you've got no documents at trial, you're not going to win. Witness statements, again, if you haven't got a witness at court, you're effectively relying on hearsay evidence, you will lose. Experts, there was a very interesting case, or mortgage valuation case, so the valuer was critical to that case. The claimant party, his expert told him that he was going to retire, but there was a mediation coming up, so the chap decided he would sit on that news and wouldn't do anything about it because he thought it prejudiced his chances in the mediation. So you could say, quite reasonably, he didn't want to damage his prospects of getting a decent settlement, went to the mediation, the claim didn't settle, he then had to deal with the fact that his expert was retiring. And the court said, look, there's no reason why you sat on this news. There's no reason why you were late coming and asking us for permission to change your expert. So you can't change your expert. You must rely on the one who is retiring. So he didn't have an expert to go to trial. His claim is really over.
This all sounds really quite scary. What are the consequences for litigation?
You have to be on time. When the court sets the directions at the case management conference and sets deadlines for the various steps to happen, we must hit them. It's as simple as that. We must hit them. We have, in fact, changed our retainer letter in litigation matters just to say that when we advise clients what the deadlines are for procedures, our clients must work with us to make sure that we can achieve those deadlines, because it is that serious that they are hit, and that collaboratively we work together to make sure we hit them. In the scenario that you do miss a deadline, you must apply straight away for relief from sanction, even if you think that you won't get it. Because if you delay on making the application, that in itself will jeopardise any chance of showing that there was a good reason, because it's yet further delay. And the chance of getting relief will very quickly disappear. If you think you're going to miss a deadline, you must apply straight away to extend the deadline. And it is much better to be applying to extend a deadline than it is to be asking for relief from the sanction that automatically imposes itself, the deadline having passed. So this all means, actually, it means more work and therefore more cost, and will probably all be irrecoverable costs, of course, because it won't be provided for in budgets or anything. More work within the same timetables. But what the courts are striving to get to, and you could say this is a perfectly reasonable position, of course, which is deadlines are set and they must be hit. And that's what it means. Now, the much more interesting question from a litigation perspective is, what if it's the other side that's going to be late? Well, that almost now does look like a rub your hands in glee moment. The courts have been very clear saying that these new rules are not to be treated as a tactical weapon in litigation. But bluntly, who are they trying to kid? Of course these are a tactical weapon. Not only are they a tactical weapon, they are a nuclear tactical weapon, because it's exactly the same in converse. If the other side is late serving its witness statements, it will be going to trial without any witnesses. That's what the rules say, unless they get relief from sanction, which is very hard to get. That changes the dynamic of the case that you are facing. They have an uphill battle. We were involved in a case where the other side was late in serving witness statements, and a week and a half later there was a mediation, and we did very well at the mediation, or our client did very well at the mediation, because the other side were now in such a hard place, having been late on service of their witness statements, and in fact not having put in an immediate application for relief. So that was a point that could be laboured against them in the mediation, duly was, and the case duly settled. That said, like everything in life, there is a caveat to all of that, because of course we are still meant to be all mates together, this wolfy idea, the wolf idea, that the parties are cooperating with each other to move cases efficiently towards a trial. So, of course, there is always a downside should you take a point against the other party and then the court decides that you have been unreasonable and you get told that you are trying to deploy these rules as a tactical weapon when you should never have been doing so. And that has happened in the Summit Navigation case, where the defendant party did take the point on a very short delay, measured in minutes, on the supply of security for costs. And Mr. Justice Leggett in that case was very clear that he thought that was unreasonable behaviour on the defendant's part. Therefore, the application that had to be brought before him for relief from sanctions brackets, even though that's what the court rules themselves say, close brackets. That application had only been required to be fought on a contested basis in front of him because of the unreasonable conduct of the defendants taking that point, and therefore the defendants would pay the costs of that application, even though it was the claimants that were late in this new, much tighter procedural regime.